Hi, it's Roland Jones. Thanks for watching. This is a video on clawbacks and the transportation and logistics industry. And I'm making a special video because there are some issues that come up a lot in this area, and it's good to know what you're facing if you're being sued for a clawback in this business, or you're corporate counsel, someone that's being sued for a clawback. And this will give you some of the issues that come up and some of the ways that they're handled. The first thing I want to talk about is a situation where a carrier may have a right to set off. And this is a fairly common situation. And of course, I want to talk about how does this help in the context of being sued for a preference, for a clawback that's a preference. How does having a right to set off going to help? First case I want to talk about is Mason and Dixon Lines versus St. Johnsbury Trucking. This is kind of an old case, 1986, bankruptcy court level, but it's a good case to illustrate the principle of using set off in a preference case, and it's also still good law. And it's also a common fact pattern, so it's a good case for these illustrative purposes. So these two companies were in the trucking business, and they participated in an interline trucking arrangement. Basically, they shipped for each other, and they owed each other money. In this slide, right away I'm going to point out that there are rules in this industry, and one of the rules provide, and I'll go into that again a little bit later, provide that each carrier had a right to set off when an account was 30 days delinquent. There's no dispute about that in this case, that's an applicable rule. M&D goes bankrupt. St. John's was paid during the 90-day preference period, and the trustee sought to recover the payment as a preferential transfer. A hearing was held on summary judgment by both sides. So that's the procedural background. The trustee argued that it met all the elements that it had to meet, and that there's no doubt that the creditor would have been paid less in a Chapter 7 case because, according to the trustee, the defendant would have had an unsecured claim, and unsecured claims were paid 10 cents on the dollar. And so the trustee is saying, Your Honor, it's a preference. They were paid 100 cents on the dollar in the 90-day period. Everybody else got 10 cents on the dollar. They were preferred, and there's no defense. I'm summarizing in a simplistic way here. And also, by the way, Your Honor, and of course he's anticipating the argument, is saying they don't have any right to set off. They got paid. Why would they have a right to set off? You only have a right to set off if you get paid, and I'll go into that in a second. Well, the defendant took exception to those arguments, of course, and took refuge in 547b5. And I'll show you that section in a second. But basically what that says is, ask the question, was the creditor paid more than it would have been paid had the company just filed for bankruptcy and had the creditor not been paid? So in other words, did the creditor get a better deal by getting paid in that 90-day period what it got paid than it would have gotten paid if the company filed Chapter 7? Again, the trustee's argument is, well, they're just an unsecured creditor. They got paid 100 cents on the dollar in the 90-day period. They would have gotten bupkis, 10 cents on the dollar, if they were just an unsecured creditor. So what's the argument? St. Johnsbury is saying, well, we had a right to offset pursuant to Section 553 of the Bankruptcy Code. And that claim, that right would have been a secured claim under 506A of the Bankruptcy Code. And I'll show you those sections in a second. But basically it's saying, if we hadn't been paid, we would have been secured creditors. We would have been paid in Chapter 7 100 cents on the dollar anyway. And so the trustee shouldn't be granted summary judgment and shouldn't be allowed to collect anything. because the purpose of the preference laws is to protect unsecured creditors, those that are getting 10 cents on the dollar, and not treat others in an inequitable way by paying them 100 cents. But the argument is, hey, we would have been paid 100 cents anyway, so we're not part of that group, essentially is what the defense is. So just to restate it a little bit, the issues are, were the payments made by M&D to St. Johnsbury preferential payments when the defendant had a right to set off at the time there was a mutual debt and had a right to set off at the time the debtor made those payments during the preference period. Also, M&D is arguing, well, it gave up the right to a set off when it was paid. It doesn't need the right anymore, it's paid. And that was a contemporaneous exchange for new value. It's giving up something. It's giving up the right to a set off. So it's giving up new value. And is that a recognizable argument that should be looked on favorably by the bankruptcy court? I'm just going to take a look at the relevant statutes a little bit. 547B. 5 is really the one that's in contention here. Also applicable is Motor Carrier Freight Claim Rule 132, exception number 2. I'm not going to read it. I think it's pretty clear. If you read it, you'll see that the defendant had a right to would have a right to set off if the payment was 30 days delinquent. In this case, they got paid, but hypothetically in 547B5, remember, they didn't get paid. That's the hypothetical. If you didn't get paid, would you have been paid as much in Chapter 7? And so it's using that ability to create a hypothetical situation. 553A, title does not affect any right of a creditor to offset a mutual debt. So it's saying the bankruptcy code does not destroy the right to set off, and that's very, very important. Also 506A1. An allowed claim of a creditor that is subject to set off is basically treated as a secured claim. Why is that? Why do we treat set-off claims like that? Well, just think about it. So it's pre-bankruptcy. In this case, the debtor owes money to the creditor, and the creditor owes money to the debtor. And so what happens after the bankruptcy if set-off is not protected? After the bankruptcy, the debtor still has a claim, 100 cents on the dollar. It's going to sue the creditor, has a completely valid claim, assuming there's nothing else going on, against the creditor. But what does the creditor have? Creditor doesn't have a claim anymore against the debtor that's going to be paid 100 cents on the dollar. All it has is an unsecured claim that's going to be paid bupkis, whatever unsecured creditors are getting paid, which is usually less than 10 cents on the dollar. So in other words, the right, if there was no statute like this, 506A1, protecting the right to set off, then you would destroy the right to set off, and you'd have a very unfair and unequal situation where you just can't set off anymore. So that's why this is important. The defendant is arguing it's given up something. So 547, it's arguing, the defense is 547. There are other arguable defenses, but it chose to argue 547C1A. We're giving up something. We're giving off the right to set off. Why are they giving it up? Because they did give it up. They got paid. It's gone. And once you get paid, you no longer have a right to set off. You don't need one. So it's an interesting situation. Well, the court was sympathetic to the defendant. And basically, I'm not going to read the slide. You can if you want. But basically, I'm going to summarize it. And the court said, hey, the defendant was mischaracterized as just another unsecured creditor. And the fact is, it did have a right to set off. And so, there's just something wrong with this picture. We've got to come up with an equitable solution here that protects this defendant. And the court is basically saying, if this were the case, if I'm going to allow a preference case and a clawback, then basically I'm going to allow a debtor to have a set-off arrangement with a creditor, pay the creditor, and then destroy the right of set-off. So that outcome would not be fair. So essentially the court decided that the defendant properly asserted new value in that it relinquished its right to its set-off when it was paid, and it granted new value in the amount of the set-off. What's interesting about this case is that it doesn't, the facts don't really fit, in my opinion, really cleanly or smoothly into any defense of the bankruptcy code. But, you could certainly make an argument of new value, and that's been done in other situations also with liens that are relinquished upon payment. And courts have basically used the new value section to try to remedy a potential wrong here, and give the defendants a way to defend themselves in a situation where they gave up something basically unknowingly, and they gave up a valuable right by getting paid. And the court is recognizing a basic unfairness of coming back 2 years later, and asserting that right was given up, and it's just too bad. So, I mean, in conclusion here, if you have a set-off situation in the context of a trucking company or another transportation company, and there is a right to set off, and there is money owed by both sides, this is a potential defense that certainly should be considered. This case is about paid new value, and I'll describe what that is in a second. This is a fairly recent case out of Delaware, bankruptcy court level, 2014. And the defendant was in the transportation business and shipped auto parts for the debtor. During the 90-day preference period, the defendant received payments from the debtor. There's no argument that it didn't, but the argument is it has a defense, and the defense is called the new value defense, which I'll go into in a second. But basically what that defense says is, okay, we got a transfer that is allegedly preferential, but right after that transfer, we provided trucking services. And the value of our trucking services should be set off against the previous transfer that was received as new value. In other words, we provided new value to the debtor. We're providing value to the debtor. We're providing trucking services. And it's assumed that if you're selling a product to the debtor, if you're providing a service to the debtor, and the debtor is in business, it's profiting from the transaction. Otherwise, it would enter into the transaction. An easy way to see that is that if you're shipping parts to the debtor, and the debtor is paying for those parts, obviously it's going to use those parts to create something and sell that final product for profit. Just as in this situation where it hired a shipper to ship auto parts, that's part of its profit equation. So that's why it's new value. We're providing the shipping service, and this is in the end resulting in a profit for the debtor. The dispute in this case was whether this so-called new value, shipping services, would have to be paid for or not. In other words, there's a division in the courts, and the division is this: you provide, the debtor pays you for prior services, then you provide new services. Some courts argue, okay, you can set off the value of those new trucking services that you just rendered after you got paid in the preference period, and you can set off the value of those services against the previous transfer, but only if they weren't paid. Only if the debtor didn't pay for those services. If the debtor paid for those services, then you're not really, the argument is the reason we're allowing you to set that off, the previous transfer that otherwise would be preferential, is because you didn't get paid. So we're taking the value and setting it off against what we should have been paid back, and that's the argument for the set-off. But some courts recognize that even if you were paid for that shipment, in other words, there's a transfer, there's a shipment, and then there's another transfer that pays for that shipment, even though that shipment was paid for, it should still be recognized as new value. And that's what this case is about. So procedurally, both filed motions for summary judgment. The debtor argued that the new value had to be paid for, and the defendant argued the court should adopt what's called the subsequent advance approach and grant the services provided, the shipping provided, deem that to be new value as well, even though it was paid for in the preference period. The statute is rather confusing on this, and I think just about everyone would agree. This is basically the argument of the unpaid, only allow unpaid new value approach. It's basically saying, the way I summarize it, which is it would be unfair not to give credit for new value in the form of services or product, in this case shipping services, and not allowing that value to be set off if it's not paid for against the prior transfer. And the other sub-argument is that the estate doesn't say, in other words, unsecured creditors that are later paid 10 cents on the dollar, they're not prejudiced. Why? Because the defendant gave new value that it was never paid for. So they got a transfer of, let's say, $10,000 and then provided $10,000 worth of services that it was never paid for. So it's a set-off, basically. That's the unpaid new value rationale. Well, I mentioned this. There is a jurisdictional split in the courts. So again, this is the argument why unpaid new value should be set off against the prior transfer. And this is the argument why paid new value should be set off as well. And what this rationale basically says is the new value is not unpaid services. The new value is that the defendant was continuing to do business with the debtor, and the debtor profited from that business. Otherwise, it wouldn't have done business with the defendant. So the argument is the creditor extended new creditor. So the creditor, in a practical point of view, looking at it practically, the creditor just got paid and doesn't know there's going to be a bankruptcy filing. The creditor may know there's financial issues over at the debtor, but the creditor just got paid, so it's shipping again. Why is it shipping? Because it's extending new credit. It's depending on continued payments. So that payment, the creditor is seeing as conduct by the debtor that indicates it's paying for its services. In this case, transportation services. So it's extending more transportation services, which the debtor is profiting from, and then it's paid for those services. But the new value is not that it extended services and didn't get paid for them. New value is that it's continuing to do business with the debtor, and that's the basic argument and rationale for allowing paid new value. Basically saying it's irrelevant whether it's paid or not paid. The creditor is providing value by doing business. This is a spreadsheet that compares the new approaches. I'm sorry, that compares the two approaches and what the different results would be. So not to beat a dead horse, but again, it is a confusing issue, so I'm repeating it. The rationale is debtor makes the transfer, creditor provides new transportation services, creditor is then paid for those transportation services, and yet those transportation services, even though they're paid, should protect the prior transfer. Why? Because the creditor relied on that transfer in continuing to provide unsecured credit. It's also providing new value in the form of its product or service, here transportation services. This is a quote directly from the opinion. Well, the story in this case is that obviously this court granted the paid new value of the provided by the creditor, and the case was dismissed with no payment. This is an important case because this still is a controversy among the courts, and if you're in a situation where you can make an argument that you have paid new value, then obviously it's worth making the argument and using the rationale of this case. By the way, this is a bankruptcy court case in Delaware. I think I already mentioned that. I'm mentioning it again because bankruptcy courts differ all over the country. So if you happen to be in Delaware, obviously you want to use this argument. Actually, let me correct what I just said. If you're in Delaware in front of the exact same judge that ruled in this case, then you should definitely use the argument. If you're in front of another bankruptcy judge, the argument might not win unless they all have coffee together and this bankruptcy judge is particularly persuasive. This is another case on new value and set-off. It's sort of an interesting case. You have to remember from earlier in the video that new value is value provided to the debtor after the defendant received the transfer in the preference period. This is also a relatively recent case. What happened here is that the debtor was in the business of transporting Ford Motor vehicles and apparently damaged the vehicles and then made a payment to Ford Motor Company in settlement of the damage issue. So they paid around $300K for the damaged vehicles during the preference period. So Performance Transportation Services files for bankruptcy, trustee is appointed, and trustee seizes payment of $300K during the preference period and sues for a preference. What's interesting about this case is that during the preference period, Ford entered into a new agreement for hauling cars, and the value of that agreement is $14 million. So essentially, Ford became a debtor of the debtor, theoretically, perhaps not in the amount of $14 million, since I'm sure that was the value of the entire contract, but certainly the argument could be made that Ford owed the debtor money, and the debtor also owed Ford money, which it paid during the preference period. So arguably there's a set-off argument. But Ford didn't make a set-off argument. If you read the opinion, it's kind of funny because you have a very frustrated judge who went on at length in the opinion that a set-off argument should have been made. But it wasn't made. And the judge basically said Ford would have won the case if it made a set-off argument. He did everything but say that explicitly. But the argument wasn't made, so it is what it is. Instead, Ford made a new value argument. Ford made the argument that after the transfer of $300K, Ford entered into a new big contract with the debtor and that was providing new value to the debtor, that had a lot of value to the debtor. So that was new value. What's interesting to me is that the debtor just damaged Ford's cars to the tune of $300K, and then Ford enters into a huge new agreement. So I find that a little strange. But anyway, that's the argument. Trustee argued that a new contract does not constitute new value. So the issue is, did the new order or orders submitted by fraud to the debtor constitute some kind of new value that was transmitted after Ford received payment of the $300K? So this is the relevant statute, 547C4. Well, like I said before, the court said there could have been a set-off argument, but for whatever reason, Ford didn't make it. And that's the set-off statute. Basically, the court said that this is not new value because Ford is not really giving up anything. It's placing an order, but it's not transferring. It's not the way the court put it. It's not taking any risk. It's not transferring goods or services and taking a risk of non-payment. It's not extending credit, and it's not really giving up anything. So it's not new value. And the court went into some examples of what might be new value. This is the case that demonstrates or illustrates the contemporaneous exchange for new values safe harbor in the context of the shipping industry. It's a very recent case, 2015, Bankruptcy Court, Southern District of New York. This case is a good case for illustrating a couple of things. First, what's interesting here is that it was proven that Lyondell's, and not disputed, that the debtor specifically preferred this particular shipping company. The shipping company, by the way, the debtor was shipping oil from Algeria to Texas, and it hired it chartered a vessel to ship the oil. And while the ship was on the way to Texas, the debtor ran into financial trouble, and the management decided specifically to pay certain vendors and not to pay other vendors. So it's a classic preference. There's just no doubt that the defendant, LR2 management, the shipper, was being preferred. So it's interesting, and it makes it clear that the defense it used were safe harbors, and a lot of people get confused about that. It's not that there wasn't a preference, it's that there's a safe harbor, despite the fact that there was a preference. No one here is disputing that this was a preferential payment. At any rate, the defendant, the defendant argued ordinary courts, but also contemporaneous exchange. And basically what happened was the ship discharged the oil, and the defendant was paid within 3 or 4 days after offloading the cargo. The defendant argued this is contemporaneous exchange, and there was intent by the parties. It also argued that there was ordinary course. The trustee argued, well, if there is new value, then the new value has to come after a transfer. In this case, the new value came before the transfer. Also argued ordinary course, that this is how not only between the parties, but also in the industry. So these are the issues. Where the transfer is protected by the contemporaneous exchange exception? Was it within the ordinary course? Where the transfer is protected by the ordinary course defense? It's a relevant statute. Well, the court was sympathetic to the defendant and ruled in the defendant's favor. It found that there was a contemporaneous exchange defense. And what's also notable is that the trustee was arguing the subsequent new value defense found in 547c4, but there's no such requirement of that the new value has to be subsequent to the transfer in 547c1. 540c1 is a whole different section. It's the contemporaneous exchange for new value section. So the trustees' counsel seem to have been surprisingly confused by that. There's also the question of intent in the contemporaneous exchange defense, which I pointed out earlier. That the transfer has to be substantially contemporaneous, but there also has to be the intent of the parties. And this can be a stumbling block, because how do you get into someone's head to prove that they have intent? It's very difficult. So that's why the case law allows for circumstantial evidence to show intent. Basically, the court found that the payment was close enough in time, it was substantially contemporaneous, and based on the circumstantial evidence, it's clear that the parties intended that the transfer also be. Also notable is that the court shot down the ordinary course, the subjective ordinary course defense, ordinary course between the parties. Why? Because it's not ordinary to be preferred in derogation of other vendors. So the court said, hey, this is not ordinary conduct between the parties. That that the vendor should be on a special preferred list. Nonetheless, the court found that the industry standard was met. Based on the evidence supplied by the experts. This next case is an example of what's called the conduit defense. This is also a relatively recent case from North Carolina. Tidewater Designs is the debtor. They were in the business of importing gift items from overseas. And Evergreen, well, there are two entities. I'll go into it in a second. Basically, Evergreen was an agent for a shipping company based in Taiwan. So what Evergreen would do is accept payments and then transfer the money to EMC, which was the Taiwanese company. So during the 90-day period, the debtor paid the agent, Evergreen, money for the ocean freight charges. And it's also important to know that the contract was not with Evergreen, it was directly with EMC. So Evergreen basically said, hey, we're just a conduit. You paid us, but we just transferred that money, and that's what our normal practice is, and we're able to prove that. And we just transfer the money right out again. Goes in, goes out. Goes through us to EMC in Taiwan. So if you want to collect this money, go to Taiwan. The legal term is initial transferee. This is the relevant section. It's 550A, 550A1. So was Evergreen an initial transferee or not? I mean, it sounds like they were. They were the transferee that was initially where the payment was initially made. But under the case law, there's certainly an argument that they were not, because a party acting merely as a conduit is not a transferee and not any kind of a transferee. And there's a Fourth Circuit case agreeing with that concept. And the court agreed. The court basically found that Evergreen was a conduit. And what was important in the court's decision is that the debtor didn't have a contract with Evergreen. Its contract was with EMC. So the case was dismissed on the conduit defense, and good luck going to Taiwan to try to collect, Mr. Trustee. I'm going to switch gears now and talk about yet another defense to a preference case. I call this the possessory lien defense. I just made that up. It's a defense under 547B5, but I'll go into what I'm talking about in a second. Okay, so this is a 2007 case, fairly recent, out of Ohio. This is actually a circuit level case. In this case, you have a debtor that's engaged in the business of commercial transportation of cargo with airplanes, obviously, and a defendant is in the business of fixing aircraft. What happens is, defendant obviously fixed the aircraft and got paid and got sued after SAT filed bankruptcy. And of course, they were paid during the preference period. And so the defense here is what's called a secured lender defense, or a hypothetical lien defense, or a 547B5 defense. And basically, the argument is, if we hadn't been paid, we would have had a lien on the aircraft. We would have been a secured creditor. So in 547B5, which you remember creates a hypothetical, if you hadn't been paid, would you have been paid more than you would have been paid in a hypothetical bankruptcy Chapter 7 case? And the argument is, no, we were a secured creditor. If we hadn't been paid, we would have been paid 100 cents on the dollar. So that's the argument. I just love 547B5 because you just make up what might have happened, and some lawyers, defense lawyers, take this to a great extreme, and making up all kinds of hypotheticals. But anyway, that's what it allows you to do. So that's the argument. SAT said, hey, we had a secured claim in the aircraft, and the trustee's argument wasn't our aircraft, didn't belong to us. So you have a secure claim with somebody else's aircraft. Who cares? You're not a secure creditor in this case. The other argument made by the trustee is that, oh, by the way, you didn't have a lien. You wouldn't have had a lien because you didn't provide the proper notice under state law. So you didn't have even if you're right, you're wrong anyway because you wouldn't have had a lien. Creditor, of course, argued, no, we had it right. This is the statute, 547B5. And you can see the hypothetical. That enables such credit to receive more than such credit would receive if the case was a case under Chapter 7 of this title. It's a hypothetical. This is a quote from the opinion, and basically what the takeaway here is: you apply state law to determine whether a lien would have existed in this hypothetical situation. Here you apply, obviously it's in North Carolina, so you got to apply North Carolina state law. Also, other applicable rules. Here, 503 of the Federal Aviation Act, which also is applicable. This is a quote from the court, from the opinion, I'm sorry. Basically, the court found that the triad, the defendant, did not have to give notice if it had possession. The court went into a lot of analysis of state law, which is not really relevant here. What's relevant is that the court concluded that the defendant had possession of the aircraft, and that would be sufficient to protect the lien on the aircraft. And so, of course, the court ruled in favor of the defendant. What's also interesting is that the court looked at the lease issue and basically said, well, the debtor had a possessory interest in the aircraft through the lease. That's enough. That's a valuable asset of the estate. And the lien, the hypothetical lien, of course, there wasn't a lien because they got paid, but the hypothetical lien would have encumbered that right. And so it's very, very important takeaway, because this fact pattern happens all the time, especially in the transportation business. It's extremely important to recognize that can be a valid argument, that just because the debtor did not own the building, the aircraft, whatever, if it leased it, this court, and it's a circuit level court, is saying that that doesn't matter. A hypothetical lien would have created a secured creditor in an asset of the debtor and against the bankruptcy estate. Also, what's interesting, in fact, I'm going to go back a little bit. No, I guess I can't. But what's interesting is that it's 547B5. It's one of the elements. It's one of the elements that's a burden for the trustee to meet. In other words, it's part of the laundry list that the trustee has to meet. And the court ruled that the trustee didn't meet it. And you can look at the last slide and you'll see. So I just think it's worth noting that essentially we're defeating an element that the trustee would normally have to prove, and the court found it wasn't proved. Okay, we're going to shift gears again and take a look at the ordinary course of business defense to the preference case, and this is in the context of the transportation industry. We found a case that illustrates the various defenses in the transportation industry in the context of ordinary course. And this involves Waterford Wedgwood against a recognizable name, UPS. UPS is the defendant here. This is also a pretty recent case, 2014. I like this case because the judge goes into a couple of different ways of analyzing ordinary course, and both sides had experts, and the expert for UPS, his basic argument was he looked at a database and he made an argument on industry standard, the industry standard part of the ordinary course defense. So remember, there are two ways of proving ordinary course. One is ordinary course between the parties, where you compare how the relationship, how the relationship transpired in the preference period and how it transpired in a base or comparison period prior to the bankruptcy case, and then decide whether conduct in the ordinary in the preference period is ordinary or not. Here, the UPS decided to use an industry standard defense, which is different. It basically looks at data, usually data in this case from credit risk monitor database, on how other folks are paid in the transportation industry, and compares that to how the debtor paid UPS during the preference period. And of course, the goal is to say it fits within the industry standard of how transportation companies pay. So the expert testified, and he came up with a very broad range, 14 to 70 days. He concluded was the normal industry pay range in 2008, and 16 to 17 days in 2009. Well, just eyeballing that, you can tell it's a huge range. It would be hard not to fit within that range. So we'll see how the judge treated that evidence. Well, like we always do, try to narrow the issue, find out what the issue is. Were the payments made in the ordinary course of business between the debtor and UPS? Really, the sub-issue also was did it meet the industry standard safe harbor of the ordinary course of business defense? It's 547B, 547C. So the relevant code section is 547C2B, made according to ordinary business terms. That's been interpreted as whether the payments were made pursuant to an industry standard. But before jumping into the industry standard analysis, the court reviewed ordinary course for the first prong, which is ordinary course between the parties, creditors. Creditor must establish a baseline of dealings, as I just mentioned, and then perform a comparison. Then the court went on to the objective test, also known as the industry standard, and basically this is the test is whether the transfers were ordinary under an industry standard. And this is often quoted: only dealings so idiosyncratic to fall outside that broad range should be deemed extraordinary, and therefore outside the scope of subsection C. So there's a lot of latitude there. I read that specifically because it's constantly quoted. There's a broad latitude in a low bar to meet that criteria. Just reading the quote itself makes that clear. Okay, so what are the four arguments made by the trustee? The trustee's first argument is that the history was inconsistent. Sometimes the debtor paid in 49 days on average, and 44 days, 72 days, and so this takes it out of the ordinary course industry standard safe harbor. But UPS argued that the trustee is just forming arbitrary groupings and then hoping in an arbitrary way and making an argument. The court held that there's nothing to do with the industry standard. The industry standard is an objective look at how on what's normal in the industry, whether the payments were within the outer limit fact that that the transactions deviated from the agreement are just not relevant. In fact, it's irrelevant to analyze the relationship between the two parties. It's not, except for the purpose of comparing that with an industry standard. In other words, it's not supposed to compare for the industry standard defense. You don't compare parties with themselves. You compare the transactions with an industry standard. Next, the trustee argued that UPS shouldn't have compared each payment and how that payment was made with the industry standard, and that was highly inappropriate, and that there was no precedent for this analysis. Again, the court shot down this argument and said the opposite, that there is precedence, in fact, in case law for analyzing ordinary course like this. And the court went on to basically say neither party really cited cases on how to perform an ordinary course analysis of the industry standard. The court looked at the analysis that's usually done in so-called subjective analysis. In other words, comparing how the relationship of the parties, and basically looked at the different ways that is analyzed, and used that, and then chose an analysis to apply to the industry standard. This is just a section of the opinion, and basically the court says, well, one of the ways of showing ordinary course between the parties is to look at the averages. Another way is to look at the range of payments, and the range of payments is basically if the debtor paid between 10 and 30 days during the comparison period, and the debtor paid between 11 and 24 days during the preference period, then the payments were within range. Total range means that you can take the entirety of the range in the base period. In other words, if the debtor in the base period paid between 1 day and 100 days, and then if the range, and that's the total range, and then if the payments were within that range in the preference period, then you can argue it's ordinary course. And the court rejected the total range analysis by saying, look, you're going to have outliers, and it's not, 1 day is not really representative of ordinary course. In other words, 100 days, you're going to have special situations and outliers, so we're going to reject that analysis as well. The court found that the best way of determining ordinary course in the context of an industry standard safe harbor defense is using standard deviation analysis. And basically, the court accepted evidence that there was a 42-day average in the data provided on industry standard, and accepted a standard deviation of 12 days up and down, and found that payments within that range were made in the ordinary course of the industry standard, and payments made outside that range were not in the ordinary course. So essentially, the court went through, took an inventory or compared different types of analysis, and decided that the standard deviation was the most fair. Trustee also argued that payments were not made in the ordinary course because UPS was paid in full prior to the bankruptcy. The court basically rejected that completely. So in conclusion, the court applied the standard deviation, which is in the context of an industry standard analysis of industry standard data, and standard deviation is a very common and accepted method of proving ordinary course. And the takeaway is can also be used in the industry standard. The formula captures 67.5% of the numbers and is deemed to be a fair sample and a determination of what's ordinary. This is another case on ordinary course. Again, in the transportation industry, this is a trucking company defendant. This is the Quebecor case, and R.A. Brooks was a trucking company that supplied transportation services. And here the analysis is a little bit different. First of all, there was an argument as to the period, the comparison period. The defendant proposed going back 1 year and comparing that to comparing how the parties transacted during that 1 year and comparing that to the preference period. And the trustee wanted to go back 2 years or more, obviously because the trustee had information that would indicate more deviance from the preference period if it went back further in time. The trustee contended that the weighted average during the preference period was 57 days and change, and the weighted average during the base period, the 2-year base period, was 27 days and change. So obviously, trustees arguing it's not in the ordinary course because the defendant got paid a lot later, significantly later during the preference period. The defendant argued that 1 year is the appropriate reach-back period, or comparison period actually, and that if you took that period, you'd have 52 versus 35, or rather 35 in the comparison period, 52 in the preference period. It's a little bit closer together, a little bit more of an argument that it's ordinary. But the other argument, which is very important, that the defendant made, was a range analysis, a total range analysis. In other words, looked at every single invoice and how long it took to pay that invoice historically for a year, and found that and had a wide range, and found that the payments in the preference period were within that range. That's called the total range analysis because it doesn't exclude any particular invoice. So the issue is what's the appropriate analysis here? Code section applicable 547C2A, made it in the ordinary course of business and financial affairs of the debtor and the transferee. First, the court pointed out what the weighted average is, and that's basically taking into account the size of the invoice and giving more weight, obviously, to larger invoices. And the court identified what the total range method consists of. And the court rejected the total range method because it found it took into consideration too many outliers, and it's not really. And the court decided it was not representative of a determination of what was ordinary between the parties. Included too many invoices that were outliers. It's not really what's ordinary. The court decided that average lateness was a good method, and also bucketing was a good method. So what's bucketing? Well, bucketing is basically saying, well, when were most of the payments made? Here the court noted that 88% of the historical payments were made within 11 to 40 days. So bucketing is doing an analysis basically to find when most of the payments were made in the historical period and the preference period, and comparing those two buckets to see if they're similar. And the court found in this case they were not similar. Found that 88% were made between 11 and 40 days, and during the preference period, most of the payments were made between 46 to 60 days. So it found that in this particular instance, the payments were not made in the ordinary course because they didn't look like most of the payments that were made during the comparison period. So this analysis removes the possibility, doesn't take into consideration a lot of the invoices and payments of those invoices, because it just looks at what happened most of the time, not what happened some of the time. Also looked at the average as well, the overall average, and found that there was a big difference. So the takeaway is this is another way of analyzing ordinary course by making a statistical analysis and determining when the majority or most of the payments were made in either period. This is another case in the transportation business. This is a carting company, removal and hauling. 2008, this is bankruptcy court level. What the defendant did here was assert the ordinary course defense under industry standard, and the defendant submitted 3 letters from competitors basically saying in this industry, you got paid between 30 and 60 days. The problem is that the defendant's invoices were issued as payment due upon receipt. And the issue is the court going to allow an industry standard because the defendant got paid within 30 to 60 days, which arguably is the industry standard, or is the court going to make an issue of the issues and the different terms that the defendant had with the debtor? Well, the court rejected the defendant's argument, but the rationale was interesting to note. Basically, the court said, okay, so the payments were between 30 and 60 days. The court basically didn't go into the issue of whether unnotarized, unsworn to letters were admissible as evidence or not. Basically, the court seemed to just consider the letters, but decided the letters said that the normal credit terms in the industry, in the carting industry, was 30 days. And the defendant issued invoices that said due upon receipt. They weren't paid. The invoices were not paid upon the receipt. Upon receipt, they were paid, 30 or above. And so the court said, well, nothing explained, nothing addressed this issue of invoices that are due upon receipt. And even though the payments were made within the range of what the letters were saying was the industry standard, it doesn't matter. There was no explanation of the practice of essentially not extending credit and demanding immediate payment upon invoice. And so the court rejected the defense because that issue was not rejected. It's just something to note if a similar fact pattern comes up, that's what happened in at least one bankruptcy case. Just to edit this slide a little bit, the Fifth Circuit, a bankruptcy court in the Fifth Circuit has said this. So just to clarify that, the Court of Appeals did not say that. A bankruptcy court said that in the Fifth Circuit. I included this case because, number one, it's in the trucking business and sort of presented a creative argument that may or may not work. I included this case because it involves the trucking business, also sort of a creative argument that's good to know about. So Leprechaun Trucking delivered trucking services and got paid for those services by Truman Flat. It also bought limestone from a company called Pana. Pana and Truman basically are owned by one principal. So it paid for the limestone during the preference period, and that's why it was sued for a preference. Well, the argument made by the defendant was basically the payment to the limestone company was really assigned to the trucking company. In other words, to the recipient of the trucking services. So that this was really a check swap. And yes, they paid for the limestone, but we had to pay Leprechaun. And so it's sort of a set-off argument, but not really, because it's saying that the defendant really did not receive this check legally, did not receive the payment legally. It was really received by the other company as sort of a set-off. So the defendant is arguing that PANA really didn't have any legal right to the payments made by the debtor during the preference period, and that these payments were already assigned to Truman Flat before the bankruptcy. Well, the judge basically said, that's not really not what happened. There's no formal assignment. There was no formal assignment of PANA's right to collect money from the debtor to Truman. It was merely a mechanism by which a PANA would ensure getting payment for the limestone, and Flat would not pay prior to PANA receiving payment, but it wasn't a true assignment. Anyway, it's an interesting case because it's just something to look out for, that the court spent an enormous amount of time looking at this, and it could be a potential argument if there were a true assignment. Here there wasn't, and there was no evidence that there was. But it may be a way to avoid preference liability, and it's otherwise instructive. The defendant also made an ordinary course argument, and the court's ruling was basically this was not consistent with past practices between Leprechaun and PANA, and PANA did not require any of its other customers to pay with this unusual arrangement. Also, the court analyzed whether it was industry standard and found that there was no evidence that this unusual check swapping arrangement was a part of the industry standard for the limestone delivery business. I'll just end here by saying the court did note that if it were one defendant, and possibly a set-off argument, obviously a set-off argument may have worked, but it wasn't. It was two separate companies, so it was just unavailable. They tried to work around that, and just was not. The judge just wasn't buying it. This is another ordinary course case in the trucking business. We have to remember here, this is a 2002 bankruptcy level case, and I'll explain why that's relevant shortly. So the debtor was in the furniture business. CRST is a trucking company, got paid in the 90-day preference period, around $40K. And what's instructive about this case is that you could see how a judge broke down the ordinary course defense extremely carefully, really parsing it out. Some of the payments were made in advance, and a lot of them were made in the 80 to 90-day range. So the defendant, of course, argued that the transfers were both in the ordinary course of business and in the industry standard. What you have to note about this is that the law changed in 2005. So this case is being decided in 2002. Before 2005, you had to prove both prongs of the ordinary course defense, that the payment was ordinary between the parties and as well ordinary pursuant to an industry standard. Well, the court did its analysis in two ways. First, took the took the averages of all payments in the preference period, compared that to all payments in the so-called base period, and found that the payments were made significantly later in the preference period, roughly 80 days in the preference period and roughly 65 days, 66 days in the comparison period. So off the bat, things are not looking very good for the defendant. Payments were, on average, made a lot later. But then the court did look more carefully and did a bucketing analysis. And like we saw before, that's basically how are most of the payments made? Or alternatively, the other way of looking at it is how were payments made? If payments were made in the preference period in 80 days, was that normal, or how often was that made? What percentage of total payments was that in the comparison period? And here, the court found that only 16% of invoices were paid in 80 days or more during the comparison period. But the court didn't stop there. It looked at the general factual pattern that was available in this case, and decided there were other indications that this wasn't made in the ordinary course. Payment number 3, the court looked at each of the 3 payments and looked at payment number 3 as made by manual check, as opposed to automatic check payment. Then it looked at payment number 1 was unusual because it was a partial payment. It was also made against an extremely aged invoice. And the court basically looked at the facts and some other facts and decided this was a situation where the defendant had leverage over the debtor and was using that leverage to get paid in a faster way and in a as it turns out, preferential way. Of course, if there hadn't been a bankruptcy filing, then there wouldn't be an issue. But there was, and the court decided that these transfers did not benefit from the ordinary course defense because they were not in the ordinary course of the history of the party. There was more leverage, and there were later payments, and they were paid in unusual ways. As far as the industry standard, the court noted that both prongs had to be proved, and since one failed already, the court did not need to go into the industry standard defense, but did anyway, and basically addressed a witness who testified that 20 to 25% of shippers get paid in the 60 to 90-day range, and the court essentially rejected the argument that there was industry standard in this case, and argued that the ordinary course between the parties could not be extended into such a broad range to prove industry standard. This case is a 1991 case, but I included it because it's an important case in the Eighth Circuit, and it's often cited. So, again, poor trucking companies, but again, a trucking company is being sued, this time by a freight forwarder, TSI. And to make things simple, it was sued for a preference in the amount of $245K and change. And it also had a set-off, and that was not really litigated. The court granted the set-off, but denied, this is the bankruptcy court now, denied denied the defenses of St. Johnsbury, said did not have an ordinary course defense. And the reason it said it didn't have an ordinary course defense is that the payments were made 60 to 70 days after invoice, and the agreement of the parties was that the payment should have been made in 30 days. So the bankruptcy court said, and I quote, "First, the transportation agreement itself defined the ordinary course of business between the parties." So it wasn't paid pursuant to the agreement, and therefore it wasn't in the ordinary course. Of course, the defendant argued, it appealed all the way to the Court of Appeals, and argued that it was made not only according to the ordinary course of the business, but according to the industry standard. Well, the Court of Appeals reversed the bankruptcy court and the district court, which had affirmed the bankruptcy court, and basically rejected the entire rationale. The agreement has nothing to do with it. What's important is what actually took place. What was the conduct between the parties? And the court did its own analysis and found that there was a lot of consistency in the way the debtor paid St. Johnsbury, but both in the comparison period and in the 90-day period. Actually, the Court of Appeals did its own bucketing analysis, this time to the detriment of the bankruptcy court decision, and found that only 21.2% of the invoices were paid within 45 days, and found that the other ones were paid significantly later, both in the base period and in the preference period. At any rate, the Court of Appeals reversed the bankruptcy court and found that these late payments, because they were consistent with past practices, could be in the ordinary course. I guess the takeaway here is that late payments can be in the ordinary course. Just because it's late doesn't mean it's not ordinary. It's an important principle, and actually somehow that's often forgotten. You know, the plaintiff will take a look at payments and say, hey, these were very late, these were late. And the answer is, so what? That doesn't matter. It depends. The only question is, were they consistent with the past period? The last case I'm going to talk about with respect to preference clawbacks involves indirect transfer theory. Basically what this says is that if you've gotten payment by the debtor in the 90-day period and you relinquished a lien because you got that payment, and of course you would relinquish a lien, you got paid, you don't need a lien anymore. But if you relinquished a lien on a third party and that benefited the debtor, in other words, you're not relinquishing a lien on the debtor's property, you're relinquishing a lien on a third party's property. But if that benefits the debtor, you can make the argument that the debtor's gotten new value because you relinquished your lien. And this case is not a trucking case, but the fact pattern can be used in trucking cases. And I have seen a number of situations where truckers or other transportation companies have liens that they've relinquished. So it's important to understand the principle. This is a recent case, very recent case, excuse me, in bankruptcy court level, 2014. Basically, you know, as I said in the introduction, this is a situation where a defendant is being sued. A defendant was a general contractor in the cell tower industry. It provided services to the debtor, and had the right of a lien against not the debtor, but a third party, and it was being sued for a preference. In this case, the defendant was saying if it had put a lien, a mechanic's lien on these third parties, and the debtor would be frozen out of contracts, it would essentially lose business, be fired, be terminated. And the fact that the defendant waived its right, got paid and waived its right to place these liens was new value because these third parties continued to do business with the debtor. What's interesting in this case is that the defendant, Northeast, actually put a value, I assume through discovery, on the value of the contracts or the amount of money the debtor would have lost, at least in gross receipts, from doing business with these third parties. So is the court going to grant this defense or not? The court went into indirect defense theory a little bit, gave an example of when it would consider indirect defense an adequate defense. And one of the important aspects that the court looked at was any money owing to the debtor, or was any money going to be generated to the debtor as a result of the defendant giving up its lien. The court noted that there was a split in the among the case law among the courts as to whether to grant this kind of defense. The court basically decided that in the Third Circuit this could be a defense, denied the debtor's motion for summary judgment, and said there's got to be more discovery, more facts have got to come out, and the court listed a couple of things, or three things, that the defendant would need to prove. Well, the first thing is that the third parties didn't have obligations that they had to perform for the debtor. In other words, if the defendant put a mechanic's lien on property belonging to the third parties, they could have stopped work. The second, or they could have stopped doing business with the debtor. The second is that the defender of the lien rights caused the third parties to enter into new contracts. And so it's a little bit awkwardly phrased because it's a hypothetical, but if the implication is that if the defendant did not waive its lien rights, then the debtor would not have gotten the new business. And also, what kind of numbers are we talking about here? What kind of value was provided by this new business? The court noted that the 11th Circuit has rejected the indirect defense, but that some other courts and circuits imply that it's available as a defense. I'm going to shift gears entirely here and talk about fraudulent conveyance just a little bit. It's a much less prevalent form of lawsuit, form of a clawback lawsuit against transportation industry defendants. But I'm going to go into one case so you get sort of a concept of what an actual case looks like in the context of the transportation business. And this is a pretty good example. 1990 case, bankruptcy court level in Ohio. Okay, in this situation, it was a unionized trucking company that went bankrupt. And prior to the bankruptcy, management and employees who were also shareholders decided to sell the company's trucks and trailers to another buyer, and also to sell shares to another company for $2.1 million. So that was done. The company got the $2.1 million, put it into escrow, and then paid the shareholders out according to the number of shares that they had. Suburban, which is the debtor, filed for bankruptcy. Trustee is appointed. And he sues the shareholders for the 2.1. So why does he do that? Well, he's doing that because he's asserting the company didn't get any consideration. It's essentially paying the owners the 2.1, but what does the company get? It doesn't get anything. It's also saying that it's leaving the company with inadequate money to pay its debts. The shareholders are saying that it's not a transfer of an interest in property, and that the debtor was merely holding these funds in trusts for the benefit of the shareholders. This is the code section 548A1BI. Transfer made, received, the debtor received less than reasonably equivalent value in exchange for such transfer obligation, and was engaged in a business or transaction, was about to be engaged in a business or transaction for which any property remaining with the debtor was unreasonably small capital. Also intended to incur or believe that the debtor would incur the debts would be beyond the ability of the debtor to pay. The trustee says this is exactly what happened. Well, the court went into a lot of analysis as to whether a trust existed on behalf of the shareholders, and the court decided no trust existed. The court decided, and I don't really give a lot of credibility to, maybe the trust argument was sort of a creative argument, but in this kind of situation, the shareholders really didn't have a chance. And the court ruled in favor of the trustee. Money that belonged to the company, instead of being used to pay debts, was paid essentially to the owner. That's a no-no, especially if you're going to file bankruptcy shortly thereafter, and the trustee is appointed. He's going to get that money back. Why? Because he's representing creditors. And the company itself, the shareholders are getting a benefit, but the company's not getting a benefit. So it's pretty clear that the trustee here had a slam dunk kind of a case. This was a constructive fraudulent conveyance action, not an actual fraudulent conveyance action, but nonetheless, the court went into the issue of whether the shareholders had some knowledge, which is not required to be proven by the trustee. But anyway, the court went into it and said, look, it's impossible for the shareholders, for the owners not to know that the company would have inadequate cash to run its business and pay creditors if it was deprived of both its trucks and the money from the trucks. What's the takeaway? I don't know. The slide is a little bit obvious, but if you're a trucking company and you want to sell your company, the proceeds have got to pay off creditors before they pay off the owners.